Welcome everyone to our webinar called Straining Under the Backlog, Fixing a U.S. Immigration Court System in Crisis. My name is Doris Meissner, and I'm a senior fellow here at the Migration Policy Institute, where I direct our work on U.S. issues, U.S. program issues. We're going to begin with just 2 points on logistics. If you have questions, please email them to events@migrationpolicy.org. We will have a Q&A at the end of the call, final section of the segment of the webinar. So please type any of your questions for the speakers into the Q&A box at any point during the webinar. This webinar marks the release of a new MPI report. It's called At the Breaking Point, Rethinking the U.S. Immigration Court System. You can find it on MPI's website. The report is the most recent piece of work, the most recent piece of research and policy that we have done on a continuing body of work that is taking place at MPI, which we call Rethinking U.S. Immigration Policy. The courts, of course, have been a troubled element of the immigration system for many years. Numerous prior looks at the court system have called for significant changes, and they are the kinds of changes that could happen only through legislation. Because legislation is so very unlikely, we don't address that issue in this work. Instead, what we have focused on here is what can be done now, what can be done with the current system through administrative executive branch authorities. Our findings and recommendations are based on extensive research and wide-ranging consultations. We've held a series of convenings. We've done many individual interviews with stakeholders, including the Executive Office for Immigration Review, whose director, David Neal, is here with us today. So we're going to go ahead now and have a presentation by one of the co-authors of the report, Muzaffar Chishti, my colleague who is a senior fellow at MPI and director of our MPI office at the NYU School of Law. And after he makes a presentation about the findings and recommendations, some of them in the report, we will have responses from 3 parts of the immigration court spectrum that are important to the operations of the courts. The EOR itself, with David Neal, the director of the Executive Office for Immigration Review, Blas Nuñez-Neto, from the Department of Homeland Security, and Blas is the Assistant Secretary for Border and Immigration Policy and the Acting Assistant Secretary for International Affairs at DHS. And finally, Jojo Annobil, who is the Executive Director of the Immigrant Justice Corps in New York from the standpoint of practitioners. So with that, let me turn the stage over to Muzaffar. Muz, please go ahead.
Doris, and thank you to everyone who has joined us this morning for this important conversation. I'm one of the co-authors of this report. The other authors, Doris, Stevia Lair, Chris Levesque, and Kathleen Bush-Joseph. They have all contributed immensely to this over the length that took us to prepare this report. There are a number of people to be acknowledged for this. I particularly want to highlight Sarah Pierce, who used to be a policy analyst at MPI, who contributed considerably to the initial thinking of this report. So the U.S. immigration court system and the immigration enforcement system are deeply interconnected. I mean, those of us who have been in the field have known that, but I think most people don't. It took us a lot of time to understand how deeply these things were connected. And they're both in some state of crisis. There are 2 million immigration cases pending in the immigration court system today. To be precise, about 1,979,313 cases as of April of 2023. And this level of backlog is a much recent phenomenon. The caseload in the last 5 years has gone up like 6 times in the previous 5 years. In the last fiscal year alone, 708,000 cases were added to the backlog. That's about 160,000 cases more than any prior year. Our analysis suggests that if, without adding any new cases, if all IJs today would just want to just bring their caseloads under control within 1 year, they'll have to quintuple their output. So we know that this is a very, very tough task ahead. And I really have a lot of sympathy for David to preside over this enterprise. But it's not just the quantity of cases that matters. It's the kind of cases that are entering the system. Today, 40% of all caseload are asylum seekers. Now, asylum cases are complex. They take a long time to resolve. It may take about 4 years in some cases just to get your first hearing, and then many more years for the case to be concluded. So these long times for resolution means two things. First is that those who was actually eligible for the protection of asylum are deprived of that for a long time. And those who do not meet the test are not really removed, because by the time the removal order happens, they have had long, deep roots in the community where their removal becomes very difficult. So the combination of these years-long backlog and the inability then, and the likelihood that they will be returned, is what we think is at the heart of our broken asylum system. Now, this brokenness, if that's the word, contributes to the pull factors at the border. This is what drives large number of people to come and seek the entry at the US-Mexico border. Now, the factors that have led to the case load have deep and wide-ranging roots. The long-standing operational challenges at the EOIR and the new flows at the border because of the crisis in the Americas, both economic and political, and other challenges of democracy building, have really contributed to this. It's the scope of these twin challenges that has made it important to address both of them at the same time. We know that the EOIR has taken a lot of steps to streamline their policies. And we know that the head of the EOIR is doing his best to accomplish the full complement of immigration judges that have been authorized. But the challenges before the court system are really very daunting. To us, it's the quantity of the caseload and the quality of the decision-making that has made the task at the EOIR very difficult. To the quantity, during the number of cases that had been closed administratively in the Obama administration were reopened by the Trump administration, which added to the whole backlog. The Trump administration had a very aggressive enforcement policies in the interior of the country that added to the caseload in the court system. And since 2016, the border crossings have accelerated, which has led to the growth of asylum seekers coming to the border and then entering the immigration court system. But cases also take much longer to complete. In fiscal year 09, each immigration judge completed about 1,000 cases per year. By fiscal year 21, the completion rate had gone down to 200 cases per year, even when new immigration judges were added to the pool of judges. Thus, more judges alone is not the answer. We know that slow hiring, high turnover, lack of support staff has resulted in overwhelmed judges. And the overwhelmed judges without any more supporting staff has decreased their productivity and has grown the backlog over the years. You know, the concerns about the quality of the decision-making has been a subject of concern for decades now. More than 1 in 5 cases decided by immigration judges are appealed to the Board of Immigration Appeals. And appeals from the Board of Immigration Appeals has inundated the appeals, the courts of appeals in various parts of the country, causing a lot of consternation among the federal appellate court judges. Now, this is the policy changes of the BIA, the ever-changing docket priorities from one administration to the other, and various recent Supreme Court directives have contributed to this diminished adjudicative quality. Similarly, the wide variation among the IJs in the same court and across different courts in the country have also led to the concerns. If you look at the rates of denial of asylum applications, they range any place from 1 to 100% in the fiscal year 17 to 22. ICE attorneys play a very critical role in the immigration court system. The volume and the nature of the cases that flow into the immigration court system has a lot to do with the prosecutorial discretion that are exercised by ICE attorneys. And lastly, the lack of representation is plaguing the entire immigration system. Respondents in immigration court proceedings face life-threatening circumstances if they're faced with removal. But we also know that representation improves due process, fair outcomes, and efficiency in the proceedings. But most people in our immigration court system today go without the assistance of legal representation. One element that has been notable in as a significant change in the border management has a lot of role to play in the caseload in the immigration court system. And that's the asylum officer rule that the Biden administration implemented in June 22, which would take all the new border cases seeking asylum to the asylum officers in the first instance and not to the immigration judges, and only appeals from that without a de novo hearing in a more streamlined basis would be taken to the immigration courts. Now that rule or the implementation of that rule has been put on pause when the administration was dealing with the lifting of Title 42. And we think that coming back to that rule is important for this case flow to come under control. We offer, and I'll be very quick about this, we offer recommendations in 5 areas. The first is to strengthen the immigration court system's management and efficiency. We believe that for the initial period of maybe up to 1 to 2 years, all new cases should be scheduled on a last in, first time basis. This concept has been tried before in the past, and that has led to good results. And we believe that will actually decrease the processing of cases from years to months. Since it does, this advantage cases were already in the pipeline, we recommend that this be tried only on a temporary basis till there is semblance of control in the backlogs. We recommend that cases that do not meet the prosecutorial discretion criteria that the Biden administration has announced and now the Supreme Court has given a green signal to should be terminated. That there's no reason to flood the immigration cases which are not the high priority of this administration. We also believe that there should be a central case referral from DHS instead of all 3 branches of DHS sending cases to the UIR. We believe that ICE attorneys should initiate all cases because they are the de facto prosecutors on behalf of the government. It would be good to streamline the process. We also believe that we should establish 2 tiers of immigration judges, like the magistrate immigration judges and merits immigration judges. That's some more procedural matters like a master calendar hearing, sort of getting a postponement on the hearing or putting in more evidence. Those kind of the functions should easily be done by a magistrate judge and not by a merits judge who should be really reserved for the full assessment of a case. And we finally believe that we should have some specialized dockets where expertise of judges can be used more prominently. That could be applied for juveniles, for families, the review of credible fear determinations, cancellation of removal, adjustment of cases, and sometimes voluntary departures. We think that will streamline the functioning of the court system. The second set of recommendations are about the asylum officer rule. We do believe that the government should restart the asylum officer rule, that we do believe that will lend efficiency for the treatment of new asylum cases and will get those cases resolved faster, and that will bring less and less cases into the immigration court system. The third set of recommendation cases are about the use of technology in the immigration court system. We believe the technology is important. COVID-19, if nothing else, taught that we are getting more used to technology in various functions of the justice system. But we should ensure that technology is used to make courts fairer for everyone involved, such as by holding hearings when parties are unable to attend in-person hearings. But special attention should be paid to use of technology when it applies to detained non-citizens and vulnerable populations like children. And the last set of recommendations involves legal representation. We know the legal representation is very critical in all parts of the immigration court system. We believe that EOIR should establish a new unit within the EOIR to devote for the coordinating of agencies' efforts for expanded representation. That unit should collaborate with the not-governmental sector for the coordination of such immigration legal representation services. We believe that we should develop new and innovative ways to scale up representation by coordinating with lawyers who take responsibility for specific parts of a case. We may not be able to today have one lawyer be involved in all cases from bond hearing to the final order removal. The distinct parts of the cases could be handled by different lawyers in various places of that life of a case. And we think that scaling up can be done only by non-lawyers. We cannot scale up this challenge by lawyers. So training and supervision of non-lawyers, accredited representatives is very important. We also believe that some accredited representatives should be allowed to do some nominal functions like filing a master calendar hearing, filing for a continuance without being a fully accredited representative. And we should probably have a third tier of accredited representatives, or people who can just file cases and file various applications without being either lawyers or fully representatives. And finally, since federal government dollars cannot be spent on representing people removal proceedings, we encourage efforts by state and local governments to provide an increased funding, which has been a recent trend, but we believe that this should be multiplied. The proposals in the report that we are putting forward today, we believe hold the potential to reduce case volumes, increase the pace of decision-making, and improve the quality of adjudications. Thank you.
Muz, thank you very much. That was a very good, tight summary. There's a lot more in this report to read about that is informative, as well as wrinkle or further ideas along the lines of the highlights that Muz presented. But that's a good overview. So based on that overview, we'd like now to hear some reactions from people whose roles and responsibilities are not only very familiar with the issues, but are implicated in some of the things that we've talked about in the report. And for that, let's begin with you, David Neal, Director of the Executive Office for Immigration Review.
Well, Doris and Muz, let me start off by saying on behalf of the Department of Justice, my colleagues at EOIR, thank you for the opportunity to participate today. I applaud MPI for your attention to the challenges that are facing the immigration court system. And as the two of you well know, even if it's difficult to hear, we appreciate the objective feedback on not only how we can deal with our current situation, but how we can improve on being a court system. I especially appreciate that your report, which is somewhat breathtaking in its scope, I commend you. I mean, it recognizes the complexity of the challenges of facing EOIR, and that much of our current circumstances originate from outside the agency. So thank you for observing that. Well, as your report points out, the sheer volume of cases that are entering into the immigration court system is increasing our difficulty as an agency to satisfy our dual obligation to be fair and be efficient. This past year, we set a record for completing cases, over 313,000 completions. At the same time, DHS was diligent. They filed over 700,000 new cases, more than twice what we could complete. This fiscal year is going to be comparable. We're probably on the cusp of completing 500,000 cases, more than we've ever done in history. And in turn, we see things are on track for 1 million new cases to be filed with the immigration courts. We have much to work on, but what we have to work on is in the context of this reality that EOR is facing. We are facing a truly daunting volume. That being the case, we are implementing mechanisms, large and small, to do everything we can within our means to complete cases more timely and more fairly. Your report touches on so many things. It's quite a buffet, I have to say, but if I may, I'd like to highlight a couple of areas that your report focuses on where I believe the agency is making strides, and I just wanted to comment on. First, fairness and efficiency are both served when the respondent is represented, or at very least, better informed. The agency is engaged in a concerted, multi-layered effort to increase legal access to the immigration courts. And that includes measures to facilitate representation and expand self-help services to pro se respondents where we can. For example, we created a national pro bono steering committee and a pro bono committee in every immigration court to engage the stakeholders in promoting volunteer representation. We've eliminated a 2-year backlog in our recognition and accreditation program. And we're looking for ways in which we can make that program more robust for the nonprofit organizations that participate. Recently, we promulgated limited appearance regulations that allow service providers to help non-citizens fill out applications for asylum and other forms of relief. That helps respondents present their case, and it creates more clarity for the judge that reviews the application. And I'd like to add that we've expanded the Immigration Court Help Desk program in the last 2 years from 5 to 24 sites. And we've reinstituted a front of the court program for volunteers to assist pro se respondents when they're in court. We've been implementing these and other measures to promote representation and pro se information. And I would be remiss if I don't point out we appreciate the excellent suggestions from the stakeholder community and their partnership on our efforts to improve representation, to increase it, and to improve our ability to provide information to respondents. Second thing I'd like to just touch on quickly is how we are working to improve virtual hearings. Muz is correct. Virtual hearings is part of our world. I appreciate that not everyone is a fan, but the virtual hearings are here to stay. They are critical to EOR's ability to conduct hearings nationwide, and other courts, criminal and family, for example, they conduct them routinely. Now, admittedly, COVID forced the agency to expand our virtual hearings program faster than we would have liked. But the agency is making considerable strides to improve our bandwidth and to improve and upgrade our technical infrastructure. As I hope will become more visible in the coming months, we are focused on improving the virtual hearing environment and experience. Last year, I issued a director's memorandum on internet-based hearings to improve how and give judges guidance on the conduct of virtual hearings. In that memo, hit upon several common courtroom practices, ranging from common sense basics, such as the judge making sure everyone in the room can see and hear one another, to operational practicalities, such as the court needs to make sure that there are points of contact for the public when there are technical issues, and instructions to the judges that all things being equal, try to accommodate the preference of counsel when it comes to in-person or virtual media. That memo is our starting point. It is incumbent upon us as a court system to keep striving to improve our protocols and our practices to make this technology as fair as it can be and as efficient as it can be. There are segments of the stakeholder community who have been quite persistent in their advocacy that EOR do a better job with this technology. And whether or not we agree with them on any specific point, I want your listeners to know that we are grateful for their efforts to drive us to be more conscientious in how we use this hearing medium. I realize we're pressed for time. I'll end my comments there. I look forward to the questions and the comments of my colleagues. Thank you again for participating today.
Thank you, David. Thank you very much. Okay, let's move now to DHS and to DHS. And we point out quite fully in this report that DHS plays an important role in the system here, that it isn't simply the immigration courts, that the immigration courts are part of the immigration enforcement system. So Blas, if you could give us some reactions from the standpoint of the work that you do and DHS's responsibilities on what it is that we're saying here and what it is that you would like to have people in the audience understand about the DHS role in all of this.
Sure. Thank you, Doris. And also want to echo David's thanks to MPI, both for producing the thoughtful report that you've released this week and for convening this conversation, which is very timely, obviously, given the events of the last few years and the numbers, the daunting numbers that David walked through in terms of the EOR caseload. I also, just want to highlight, what you said earlier, which is, it is clear that the length of time it is now taking to get through the immigration court process has become a significant pull factor that is driving migration throughout the region. We see migrants now routinely paying smuggling organizations, what are vast sums of money for them, often more than $10,000 to $15,000. To facilitate their journey to the border. This is so lucrative, in fact, that we are now seeing the drug cartels increasingly becoming a key player in, not just collecting taxes for people who transit through their territory, which is what we saw historically, but actually, moving people and becoming deeply involved in human smuggling, not just in Mexico, but throughout the region, including, in Colombia and the Darien region. And the simple fact is that this entire system that we're talking about was developed decades ago during an era where 98% of our border encounters were Mexican nationals who were coming to work, and really limited numbers of people were seeking protection or claiming asylum at the border. Today, by contrast, Mexican nationals are accounting for somewhere between a quarter and a third of our encounters, and the vast majority of the people that we encounter at the border are coming from other countries, many of whom ultimately seek protection, even though relatively few of them actually end up receiving it at the end of this process that takes many years. And we can obviously debate many of these underlying issues, and I know there's a diversity of views probably in our audience and in the country here. But I think the bottom line that David mentioned as well is that our system that includes EOR, it includes DHS and other key players, such as the Marshal Service, we're just simply not resourced to keep pace with the changing demographics and just the increase in numbers that we have seen at the border. We, like EOR, have been committed to finding ways to streamline all of our processes. And as everybody knows, we've taken a series of steps using our executive authorities, and that includes, the asylum officer rule, which you mentioned, Doris, the dedicated docket, and of course, the circumvention of lawful pathways rule that has been in the news this week. And all of these measures were intended to address, some of the issues and challenges that we are seeing with the system. We've also been working internally on, I think, critically important and what I think will be transformative measures, including the digital A-file initiative and our ability to produce electronic NTAs that will significantly streamline our processing at the border and ultimately our, communication with EOR in terms of sharing information. Those efforts are well underway and are already starting to yield some beneficial results. And we hope in the coming year that will, filter throughout the system. I think in terms of the specific recommendations that you've made in the report, we will certainly look at how we can implement some of them or consider implementing some of them. From our standpoint, we have been, as I said, focused on streamlining the handoff between our agencies and EOR to make it seamless, to allow for the scheduling of hearings and the transfer of information, to not have to go through email and, even phone calls as we had traditionally done, but through these digital processes. I'm intrigued by the recommendation about having OPLA do all of the referrals. We'll have to look into that. I will say that within our DHS ecosystem, OPLA is one of the most under-resourced parts of the immigration system at DHS. And so that may be a challenge, but it's certainly one we can look at. I was also frankly intrigued by your recommendation that the courts consider going to a last in, first out model. We have been obviously doing that ourselves here at DHS in many of our asylum processes in order to expedite, kind of reduce the length of time it takes people to go through the process. And I think that's something we will likely want to explore, although I appreciate that that is a complex system. I would be remiss, Doris, and I know you said in the beginning that we are focusing on administrative things we can do, but I will note that I think it is, clear, and we are clear-eyed that the only real lasting and durable solution to these challenges that we've described today, involves the U.S. Congress updating some of these laws. I think the bottom line is that we will have, I think, for the next few years, a significant number of new people entering the immigration court system, even as EOR, as David noted, is taking extraordinary measures to process record numbers of people, as are we, but we are encountering record numbers of people. And so the system is just not keeping up with what we are seeing at the border, particularly, as I said, the changing nationalities that we've been encountering at the border, which we can certainly talk about. But, I think this is a really complicated challenge that we obviously, will need to address, and really just want to end by thanking David for EOR's partnership. We have been working, I think, more closely with EOR in the last few years than we ever have before, and that will obviously be critical as we move forward in the future. So thank you, Doris, and look forward to this conversation.
Thank you, Blas. Thanks very much. And certainly thank you for pointing to Congress. We always need to do so. But in the meanwhile, thanks for the ideas that you have suggested here. Some of them I hope people will ask further questions about when we get to the Q&A. But before that, Jojo, we're turning to you now as a practitioner. You deal with these issues every day, and with one of the largest legal services entities in the country, the Immigrant Justice Corps in New York. Talk to us and our audience about how you see these issues and how you see some of these ideas.
Sure. So Doris, thank you so much to you and MPI for this invitation. And I want to acknowledge my fellow panelists for their work as well. Just wanted to say, I have this forum, so I want to thank all those who've been doing this work. Really applaud the lawyers, non-lawyers, social workers, accredited reps, law students, clinics, who have basically been doing this work for a very long time. It's challenging, but you are always there, trying to protect our clients and keep families together. Thank you. My comments are informed by my own experience and also the experience from our fellows, young, newly minted lawyers who are coming into this field. Before I start, Mus, so you quoted 1.9 million people in removal proceedings. Track numbers is now 2.4 million. Tells you how quickly this number is increasing, out of which about 990,000 are asylum seekers. We talked about how EOIR has closed a lot of cases. Track says about 480,000. 179,000 were deported, and only 17.9% had counsel. So what you have done with this report is basically highlighting one of the most crucial parts of this problem: access to counsel. It's of utmost importance. I'd like to talk about a few things that we are seeing on the ground and then link it to some of the recommendations you've made. So on the legal services front, I can tell you right now that everyone is at organizational capacity in terms of staffing, in terms of infrastructure. We have cases that have been on our books for a very long time, cases that are not closing, cases that are pending, right? Making it very difficult for us, even when you implement initiatives, for us to be able to participate fully in it. Take the asylum rules and the asylum busing that recently happened. It's been very difficult to provide representation. So what have some of our organizations done? Look to clinics, asylum clinics, Pro Se Plus, which is that you help them file the application within the 1-year deadline and also help them file for employment authorization. I also want to talk about late notices and no notices. We've seen a lot of that recently for some time now. It's really rare. Just imagine sitting in your office, going through the EOIR case management system and realizing that the case that you were preparing for November, you have other cases you're working on, has been brought in to August or even July, and have to prepare your client to be able to go in and litigate this case. It's causing a lot of confusion amongst our staff because it's very unnerving. Instead of doing, let's say, 2 hearings a month, we are turning around and doing 10 hearings a month. It's not possible for us to continue doing that. We're also having challenges with biometrics. We understand that our clients have to be fingerprinted. They're always fingerprinted at the beginning of proceedings. However, they also have to be reprinted if the prints are more than 15 months old. Why is the burden still on our clients to do that? There's a 9-month backlog. If fingerprints are not current or refreshed, that means that cases are put over, right? Prolonging the time we have to work on these cases, or decisions are not made. I also want to talk about detention, transfers. So we are seeing a lot of transfers from places where there is representation, New York, New Jersey, Maryland, Illinois. All these people and all these states have implemented representation, universal representation, where immigrants will get counsel. We are moving them to the Southwest, where there are not enough resources. We have resources in New York, New Jersey, and some of these places, but can't find our clients because our clients are stashed away in Louisiana. So when we talk, Muz, about all these recommendations you're making, a critical part of it is that will our clients have counsel? Will EOIR? Let's look at what is the lowest hanging fruit that we can work with. All this requires collaboration. There are 3 stakeholders in this work: EOIR, the government, respondent, and lawyers. We have to work together. So as we think about some of these recommendations, based on what I've just told you about our challenges, taking what you've just said about what we can do in immigration court, recalendering, triaging cases. Yes, we can do that. It can't be one-sided. Let us be participants in it. We can also help. Give local jurisdictions the authority to make decisions. We constantly hear, I have to check in with Washington. Washington can't make all the decisions. Sometimes local conditions require that we make certain decisions very quickly to move this thing. We started this conversation with a report that was written recently at 1.9. We are 2.4. Maybe in 3 months when we talk again, we'll be talking about 3 million. There is an urgency here, an urgency to fix this, an urgency to do something within the next 15 to 18 months. We have an opportunity to do that. And looking at Muz, I appreciate this whole idea about non-lawyers. We can't do this work only with lawyers. We have to continue to train non-lawyers, accredited reps, to be able to do this work. And we've been trying to do some of this work. I applaud the philanthropists and foundations who've put money into this to move the needle, but we can't do it alone. We have to do it with government. And I would love for us to collaborate more, set up working groups in each jurisdiction. We've done it before. We did it in New York during the influx of children, and it worked, where government, nonprofits, AILA, and EOIR came together to figure out how do you work together to make sure that you can protect the interests of children or families and others. We can't put in measures where we don't have lawyers. The new asylum rule, fine, we can work on it, but you have to have counsel. There has to be some measure of counsel in it. So I'll stop here and we'll take questions.
Okay, we've set the table now with all kinds of issues and perspectives, and so it's time for the audience to weigh in. We have quite a few questions that have already come in, and I will try to get to as many of them as I can. But while we're doing that, please type any further questions into the Q&A or the chat box, or email them to events@migrationpolicy.org, or you can also tweet your questions to @migrationpolicy or hashtag MPI.discuss. So let me go to some of the questions that have been up here. First of all, is a question for you, Blas, and that is on the recently expanded legal pathways, the family reunification program, humanitarian paroles, etc. Can you talk about the degree to which they are easing burdens on the immigration system? Are they easing burdens on the immigration system? But
I'm sorry, Doris, you broke up for me. Can you repeat that?
okay, so the question is, the programs like the recently expanded family reunification program, humanitarian paroles, etc. In other words, the legal pathways that the administration has been establishing. Can you explain how they help ease the burdens on the immigration system overall?
Sure. So, I think in general, our approach has been that, we would like to see individuals using safe and orderly pathways and processes and to come into the country. There are obviously a wide range of different measures we've taken over the last 2 years to try to incentivize people to use these pathways. That obviously includes the family reunification parole programs that you mentioned, which allow individuals who have U.S. citizen family members in the United States to rejoin their family here and go through the green card process while they are in the United States. We view that as a significant benefit, both for the individual, but also for us as a department and the immigration system at large, because some of those individuals lose patience with the process and sometimes come irregularly into the country, and that puts an enormous strain on the families and also on our system. I think some of the other processes you mentioned, our Cuba, Haiti, Nicaragua, Venezuela processes. Those individuals enter with a grant of parole that is valid for 2 years. These are many of these individuals are people who would otherwise have chosen to cross irregularly at the border. We think there's a significant public benefit associated with channeling people into these lawful processes and reducing, importantly, the number of encounters we see, in between ports of entry who end up in the immigration court system. And so that is, kind of the overall thinking of the department. And obviously we are committed to continuing to impose consequences on those who come in between the ports of entry, and we can talk a little bit about that if people have questions. Thank you.
Okay, thank you. Now, this is a question I think, David, that you would be able to answer. Maybe it, and let me ask it, and then you can tell me and we'll figure out. The question is, why are we not allowed to adjust our status when we have a pending asylum case if we have other legal paths for a green card? If we're allowed to stay in the country legally, why should that not be sufficient to adjusting our status in the country? Would you know how to answer that, David?
With apologies, Doris, I have to admit, I can't make out everything you're saying. Could you repeat it, please?
Oh dear, I guess we're having, okay. Let's see. Why are we not allowed to adjust our status when we have a pending asylum case if we have other legal paths for a green card? If we're allowed to stay in the country legally, why should that not be sufficient to adjusting our status in the country? Maybe that's a specialized legal question that we'll have to get to separately. Does anybody know the answer quickly, or should we answer that after the webinar when we talk to a lawyer? Moose, do you know the answer?
Well, Jojo is the best person on this panel, but my assumption, this is a statutory issue that people who did not enter with authorization are barred from adjusting status in the United States. And I think that's where the disqualifying criteria comes in.
So it is statutory. Okay, then let me go from that to a question for you, Blas, which is that the administration has said it will issue a rule to define the ambiguous particular social group asylum ground, in part to improve court efficiency and adjudication. Is there a time frame for that rule to be issued?
So we have been working, steadily on the rule. I don't have a time frame I can share other than to note that it, continues to be a high priority for the department to, promulgate this regulation. As I think everybody knows, the rulemaking process can take a great deal of time, and this rule in particular is pretty complicated. But I think the goal of the rule is really to streamline the adjudication, of a lot of these particular social groups and other matters that right now are handled differently depending on what circuit an asylum office is. And so we'd like to really streamline the process, both to benefit our asylum adjudications, but also obviously to benefit individuals who are going through the process.
There is a question here. How much will it cost above current appropriations levels to implement these recommendations? I can answer that. We don't know. We have not been able to make those calculations, but I'm going to turn that into a question, I guess, again, to Blas. Could you explain what is in the current budget request, assuming that we get a budget this year that might help the resource picture for the immigration court system?
Ooh, I don't have those numbers in front of me, Doris. I could say, yeah, so, we have been consistently asking, for example, for additional asylum officers, through our appropriations in order to fund the AO rule that you mentioned, as well as other work that the Asylum Corps is doing. I think we have like EOR, we have a huge and growing backlog of asylum, affirmative asylum cases that we need to really address. And so we will continue to seek congressional support for increasing the Asylum Corps. In terms of the things that are in the report, I think the one that most directly would impact us are the recommendations, both to try to terminate cases using prosecutorial discretion and also to centralize referrals through OPLA. Both of those recommendations would require significant increases in OPLA staffing. And I know we are seeking additional OPLA personnel, but probably nowhere near enough to actually implement those two recommendations.
Doris, if I may offer something in complement to what Blas was saying. I don't have specific information at my tip of the tongue, but The package also would include another 150 immigration judges if it goes through. As you may know, we've made a concerted effort to increase the size of our immigration judge corps, and that we are guardedly optimistic that we're going to reach the appropriated level of 734 judges by the end of this fiscal. If the budget goes through as we hope, there'll be another 150 judges and, of course, associated staff. Whether that's enough to address the larger picture remains to be seen, but we're hoping for a significant increase in our resources with the next budget. But like everyone else, we're waiting to see where the Senate and the House come out in the end in their negotiations.
If I may, Doris, I mean, and you've spoken about this in the past as well, but I think one of the challenges we've seen over the last few decades really is that, we continue to resource frontline enforcement at the border at a much higher rate than we do the rest of the system. And, that has just consistently happened. Every time there's a debate about what's happening at the border, we see increases for CBP, and they to be clear, they need those resources, but we also need to resource the rest of the system to keep pace with what we're seeing at the border. And we just simply haven't over the last, many, many years. I think that is hopefully starting to change a little bit, but, hiring people in the federal government is a long and painful process, and so, appropriated money today really will only start yielding results in a year or two. And so that's why we need to make sure we're constantly advocating for that kind of funding for, our Asylum Corps, for EOR, for the U.S. Marshals to help with the rest of the system.
Well, that's certainly the case. And what we try very hard to point out is exactly that this is a system, and the system can only really work effectively if it's able to work together effectively from a resource standpoint. So let's go to this issue of last in, first out. That is part of our recommendations here. David, let me ask you, from the standpoint of the courts, does a last in, first out system create any improvements for you, or does it lead to reshufflings that ultimately become more complex and don't achieve their goal? What would be your reflections on the last in, first out effort?
Well, frankly, as a strategy, much of it depends on what's the devil's in the details, right? Because on the one hand, and then your report points this out, there's an advantage in that you're going to get more immediate turnaround for the more recent cases. But you have to be mindful of what is the domino effect for the folks that were first in, and what's the impact on cases that are already long pending. I actually think it's intriguing, and I want to not only talk to folks internally, but with my government colleagues, right, the Department of Homeland Security, because we do want to maximize the turnaround time. So receptive to it, but to be honest, I've seen it work well and I've seen it work poorly, depending on the parameters. So it's worth thinking through, but I would want to think through particulars before I know how applicable it would be in this instance.
Can I jump in here? I think I started by talking about our organizational challenges. And when we go to a last in, first out, it leaves a lot of our clients without remedy because, for example, I have an asylum client who's been waiting 4 years, 5 years for a hearing. Suddenly we go into last in, first out, and their case is recalended 2 more years. They have family abroad that they would like to bring in. So we've seen this happen most recently when judges were sent to the border to basically deal with issues at the border where people who didn't have counsel were deported. If we're going to do that, it has to be married with representation. There has to be representation attached to it. It can't be a system where last in, first out, and people are being shuffled out and deported without representation. Counsel is so important in this. We've seen how staggering it is in terms of outcomes. I just also wanted to touch on something because we don't have a lot of time, but someone had asked about accredited reps. There's a lot of work being done with non-lawyers currently, where there's a VISTA program that trains non-lawyers. At IJC, we are also working on community fellows who basically are doing some of this work. But basically, what we are saying is that there's a lot more that can be done. So there's training opportunities, there are recruiting of non-lawyers to be done. And I just wanted to make sure that that is made clear here. Thank you.
Blas, this is a question for you, and it has to do with the point you made about delays in the court system being pull factors. Could you expand on that point? What's the relationship?
I kind of referenced it in my introduction. You know, we are many these days, in order to come to the border, the majority, if not, you know, the vast majority of people we encounter have had to engage smugglers for, you know, large portions of the journey. Many of the people, you know, who are not from Northern Central America or Mexico that we encounter, which these days, you know, represents an enormous proportion of our encounters, are transiting the Darien as well. And the cost of this journey can be in the $10,000 to $15,000 per person in order to come to the border. And when you think about the fact that many of these people are coming from, you know, countries that are challenged economically, that is just a huge investment for people to be making. And one of the questions we have to ask ourselves is why? Like, why would someone pay that much money to come to the border? And I think the simple answer is that, you know, the length of the process once they arrive means that people can, you know, and once they're in the immigration court system and they have, you know, filed the requisite paperwork, they are eligible for employment authorization, which is obviously something we support. But that means that they have years to, you know, live in the U.S. and go through the process and earn money, right? And they can support their family members back home during that process. All of these factors together, I think, are just drawing people to come, because even if someone is ordered removed after, you know, 4 to 6 years, that is still a substantial amount of time for people to be able to be in the United States and working through the process. And so, you know, again, I think these are all things that are important. We want to be able, we want people who are in the process to be able to support themselves. So the EAD is critical. And we have actually streamlined the process for people to apply for EADs. But I think the confluence of factors together, you know, make it, especially in light of, you know, continuing, Congress's continuing inability to provide other legal means for people to come. I think we are, you know, seeing the court system essentially become a proxy legal pathway for people to come into the United States and work while they're here. And, you know, I think that is just an increasing challenge that we are facing, and it's leading to these huge backlogs that we are seeing in the courts as well.
Okay, thank you very much, Blas. We have come to the end of our time. There are a considerable number of additional questions that people have written in. We will try to answer as many of them offline as we possibly can. But let me thank you for your audience. Thank you to the audience for all of your interest and your attention. Thank you particularly to our panel, Muz, Blas, David, Jojo, for participating and for being part of this exercise. There will be an audio and video recording available on our website of this event. Reporters who may have questions can contact Michelle Middlestott at migrationpolicy.org with follow-up questions. Please make sure to check MPI's website for our new report at the breaking point, Rethinking the U.S. Immigration Court System, and also check out all the other reports that we have released on the various components of the U.S. immigration system that are part of our Rethinking U.S. Immigration Policy initiative. Thanks, everybody, for joining us.